Welcome to Rental Rights 101. My name is Barb Van Hoy. I'm with the City of Colorado Springs Housing and Homelessness Response Department, and I'm very grateful to be able to partner with a lot of these organizations in our community to put on these workshops. We do them about 4 times a year. We also record them and share the slides and the recording online. For those of you who did not either pre-register or sign up on the sign-up sheet in the back, you can do that, and we will make sure that you receive those. We also post them on the city's website for our departments and share them in our newsletter. We'll hear from, I think, some of the organizations who are part of our partnership about what services they provide, and then we'll welcome Clinton with Colorado Legal Services. Elisa, do you want to go first? So Elisa is with the Community Economic Defense Project. I can always say that if I'm not on camera. Yes.
It really is. Thank you. Thank you, Barb. Hi, everyone. My name is Elisa Rizzo. I'm here with CEDP. I'm going to share some information about some of the services we have. We hold a statewide Colorado Rental Assistance Grant. This grant is to provide rental assistance for anyone who is facing eviction. There's a few other eligibility requirements. There are flyers on that back table that has information about the program, how to apply, eligibility requirements. Also, we have utility assistance through Energy Outreach Colorado. So this is separate from COPE or LEAP, and we're able to provide up to $500 of utility assistance for past due rent or past due utilities. The flyers are over on the back table. Next, I want to share with you all an event that's taking place this Saturday. It is the Colorado Springs Tenant Union launch. It'll be happening from 10 to 2 p.m. at the First Congregational Church. And what is a tenant union? If you think about a labor union, it's similar to that, but it's with tenants. This will be a great opportunity to get plugged in, learn a little bit more about how a tenant union functions, and if it's something that you're maybe looking into, gathering together with your neighbors in your building if you're seeing some issues with your landlord. That will be happening at the First Congregational Church. And again, there are flyers on the back table for all of these events because it is a lot. The last one is April 14th, we will be hosting a Southeast legal night, a housing legal night. So tonight, Clinton is going to go over a large amount of great information with you all. And the questions he will be able to answer are going to be very limited, and he'll share his disclaimer when he comes up here. But this event in particular is intended to be a space where tenants can ask their specific questions to attorneys. This will be happening April 14th at the Family Success Center from 4 to 7 p.m. So you'll get the opportunity to have a free brief legal consultation. And then there will also be a short little Know Your Rights workshop that's going to be around rental basics. So what does it mean when I'm renting? What can a landlord do when I'm about to rent an apartment or a unit? I think that's all of the events. Again, there's more information on the back table that goes over the emergency rental assistance. We do get a lot of questions on that, and that is for anyone who is facing eviction. Our office is located at the Family Success Center, as Barb mentioned. And if anyone comes into our office and they are facing eviction, we're able to help them understand the eviction timeline and get them connected to other resources like Colorado Legal Services. Yeah. Any questions? Great. Okay. Thank you.
Thank you, Elisa. And then next is Deb Hamilton, who is the law librarian with Pikes Peak Library District. And we'll also talk about the Justice Center.
Hi, welcome everyone. My name is Deb Hamilton. I'm the law librarian here. I'm based out of this downtown location. You probably walked by all of the law books coming back to this room. So I just want to let you know we do have a law library that is free and open to the public. I can assist you with legal research. I'm a librarian, though I'm not an attorney, so I can't give legal advice, but I can help you look up statutes, court forms, connect you with legal services in the community. So I have some business cards on the back table. Feel free to grab one of those on your way out. I also have some other flyers back there for other legal classes that we'll be offering at the library in the next few months. And those cover everything from sealing criminal records birds, divorce and custody, protection orders. So a lot of good stuff going on. The other organization that I want to talk about too briefly is the Justice Center. They are a legal services nonprofit here in town. They offer free and low-cost legal help. They also have a great service every Wednesday night from 7 p.m. to 8:30 p.m. They have a call a lawyer service where you can call in and talk to an attorney for free. The number to call for that is 719-473-6212. And they have some flyers on the back that has that information about the call lawyer service, as well as some business cards as well. They also have an email a lawyer service too, that you can email in questions anytime. So that you would go to their website, which is justicecentercos.org, and then it's just /email. So those are two really great services. So I'd recommend checking those out if you have follow-up questions after this presentation. So that'll be happening tomorrow night. So really good timing. All right, thank you.
Thank you, Deb. And I am just really quickly going to share the City of Colorado Springs does have a housing help and resources website, and that is hopefully showing, available online at coloradosprings.gov/housing help and resources. This is one of the community's large lists of organizations that provide services for people, lots of different housing related and some not housing related. And as I'm mentioning this, I don't know if Deb specifically mentioned, the library also has a list called Helping Hands that is a large list of organizations in the community that serve folks who are needing help with lots of things, including housing related. So with that, I am honored, as always, to introduce Clinton Albert, who has exclusively been a tenant rights lawyer, landlord tenant lawyer with Colorado Legal Services for many years. So thank you so much.
Thank you, Barb.
Clinton, stop sharing so you can
Sure
share.
thing. All right. All right. Evening, everybody. My name's Clinton Albert. I'm an attorney with Colorado Legal Services. Tonight, we're covering, if you've been to, show of hands, anybody been to a prior presentation? All right, don't see any hands. Oh, yeah, that you don't count, Deb. Sorry. But tonight, we are covering one subject in depth. All right, so keep in mind, this presentation is for informational purposes only. Housing issues, the problems that come along with them, they require a thoughtful analysis of both the fact and law. So if you want to raise your hand tonight and say, my landlord is, please don't. What I would recommend doing is either contacting Colorado Legal Services to apply for assistance, the Justice Center on Wednesday nights, or you can come see us at the Family Success Center next month. Tonight is just not that forum. All right, we have a lot of information to go through. I am not going to be stopping for questions along the way. If you have a question, write it down. It might get answered along the way. So here's information on how to contact Colorado Legal Services. We are a statewide organization. If you find yourself moving, or if you do live in another county, we do serve every county in the state. So you can check our website for the local office. So this evening, or I guess over the last 8 years or so, as we've been doing these presentations, there is one subject matter that comes up repeatedly: the warranty of habitability. All right. So the warranty of habitability is the promise. If you are online, please mute yourself. That way we don't get any background feed. Thank you. So the warranty of habitability means that in every rental agreement, the landlord is promising that the home is fit for humans to live in at the beginning of the tenancy, and that the landlord's going to maintain that habitable standard throughout the entire tenancy. There are some situations where the warranty of habitability does not apply. Those are very limited situations. The main type of there's a group of them. The one kind of standard landlord tenant or standard kind of rental agreement that we may see is where somebody's renting a single family residence. That's key there. So we're not talking about duplexes, triplexes, multifamily housing. The resident doesn't receive any kind of subsidy from any governmental source. This is private landlord, private tenant. There is a written agreement that is separate from the lease agreement. All right. So this isn't clause 4 in the lease. This is a separate lease. This is a separate lease that has some kind of consideration. Maybe that's a reduction in rent. And what it means is that the tenant is agreeing to take on a certain work in the property, a certain work in the rest. Let's say they are an electrician by trade, so they have that experience. Maybe the landlord then they come to an agreement that, hey, you're going to take over the electrical, you're going to take over electrical maintenance, and I'm going to reduce your rent by $200 a month or something like that. You sign that lease agreement. Now that condition isn't part of the warranty of habitability, because you've said, hey, I can take this on. I have the skills to do it. We've signed an agreement and I'm receiving something in exchange for my expertise and service here. Can't enter into an agreement that would endanger the health or safety of the tenant. Any other type of agreement which is waiving or altering the rights under the warranty of habitability is not going to be enforceable as a lease clause. All right, so that was kind of the normal one. Here's the hodgepodge of random ones. If we have any kind of residencies in public or private institutions incidental to detention or as a provision of medical, geriatric, educational, counseling, religious, or similar service. Occupancy, if a house is being sold and then either the buyer or seller is still living in the home before closing. If we have a fraternal or social organization and structure that is operated for the benefit of that organization. And again, just to kind of recap, I know I'm flying through these. That's because these are rare. All right. And these are situations in which the warranty of habitability does not apply. Hotel or motel stay that's less than 30 days. Day 31, we're in a different world. All right. If you are an employee or an independent contractor and the housing is being provided and conditioned upon said employment or contract, occupancy in a recreational structure, hunting cabin, yurt, hut, etc. So that's where we're not seeing the warranty of habitability pop up. All right. So that's done. We're moving on. So we're talking about it. As we're talking about it, the warranty of habitability is a duty that the landlord has to us as tenants. And if a landlord breaches that duty, then they're not doing what they're supposed to be doing. So what does it mean to breach the warranty of habitability? That means that the premises itself is going to be uninhabitable by a condition listed out in the statute or in a condition which materially interferes with the life, health, or safety of the tenant. The landlord has notice of the condition. That's a big thing, notice. All right, and we're going to talk about what counts as notice, because if you can't put something in writing into a court filing, you don't have notice. All right, and the landlord then fails to take action in the times required, starts the repairs but doesn't finish them, or starts the repairs and just keeps kind of going at a snail's pace to where it's not being completed in a reasonable time. Additionally, if like we said a couple slides ago, the warranty of habitability is a promise that the home is fit to live in when you move in. So if your landlord rents you a property that is uninhabitable when you move in, you do not need to provide a notice and you can pursue any remedy because the landlord is in breach from the beginning of the tenancy in that situation. So we're taught the landlords, obviously, we're going to be focused on a lot of what the landlord's going to have to do in response to breaches. But keep in mind that when you're living in a place, you also have responsibilities too as a tenant. If the lease identifies anything, any maintenance that you must upkeep, and we're not talking about the electrical work, right? We're not talking about getting into the HVAC and cleaning that all out. We're talking about cleaning, keeping any kind of obligation that may come under there. All right. And then to use the portion of the premises within their control, that part about in their control, think about if we have a shared rooming situation, and that the tenant's using that in a reasonably safe and clean manner. You can't destroy the property. You do that, you're also facing a possible substantial violation. So what does safe and reasonable use mean? Safe and reasonable use means the following. That means that as you're, throughout your tenancy, you're going to comply with building, housing, health codes, materially affecting health and safety. You're going to keep the residence reasonably clean, sanitary, as permitted by the conditions of the residence itself. Let's say you're dealing with a mold issue. If you're not responsible for remediating the mold. So you're responsible for cleaning it as much as you can, given that situation. Okay. Disposing of ashes, garbage, rubbish in a legal manner. Using all of the facilities and appliances in the residence in a reasonable manner itself. Don't disturb your neighbors' peaceful enjoyment of their premises. And also, here's a big one. If you notice something in the home that seems uninhabitable, as a tenant, you've got to tell your landlord because they don't know unless you tell them. And also, that's really easy notice to create as well, is telling your landlord, hey, I have an uninhabitable condition in my home, and here is the condition. So you have to do that as soon as you realize it. If it's uninhabitable, or if you're saying, hey, that window is kind of getting pretty loose, I think it's about to fall out of the frame. Because when the window would fall out of the frame, that would be an issue. All right. We're now at the conditions. So what is it that we're talking about? What are these promises that are being made? So it's the promise that your home does not have mold in it. Again, folks online, if you could please mute yourself. All right, so mold, that's dampness, which is mold, or if left untreated, could cause mold. We'll get to the procedure there, but this excludes minor mold or mold found on surfaces that can accumulate moisture as part of their proper functioning and intended use. What does that mean? In short, air out the bathroom. All right, there's going to be moisture that accumulates. Air it out. If you keep it all trapped in, you're trapping the moisture in. That's an easy example. I'm sure there are other ones. That's just one that springs to mind immediately. Appliances are also covered. The appliances have to be functioning and they have to conform to the applicable law at the time of installation. They also have to be maintained in good working order. You're going to hear the phrase good working order a lot throughout these conditions as we're going through them. There we have the definition of what an appliance means. It's going to be refrigerator, range oven, stove oven, air conditioner, permanent cooling device, portable cooling device that's included with the residence by the landlord. Landlords aren't required to provide these appliances, but if they're in the lease agreement or actually provided at the beginning of the tenancy, then that appliance is going to then be covered by the warranty of habitability. All right, we also need proper roofs, doors, and windows. All right. Now, this is where we're going to see this condition pop up in a more severe category later when we get to conditions that materially interfere with life, health, or safety. But here we have leaks, right? We have waterproofing and weatherproofing where we don't have windows, walls, in good working order. This also includes unbroken windows. So let's say you got the window seal in there, but it's a single pane window. It's old, and every time it rains, you're going to know it because it's going to be leaking on the inside. That's what we're getting at here. All right. Plumbing and gas facilities, they have to be connected. They have to be installed in conformance with the law. They have to be maintained in good working order. Running water and hot water at all times, and in an amount necessary for us to all do our daily activities, like showering, washing dishes, prepping food. All right. They also have to be appropriately connected to a sewage disposal system. Heat, again, we have to have functioning heating facilities. All right. That their installation conforms with applicable law, maintained in good working order. Lighting and electrical system, we see the same thing here. All right. Bless you. Again, conform to the applicable law at the time of installation and maintain in good working order. I know I sound like a record or a CD skipping right now as I keep going at time of installation, maintain in good working order, but that's really what we're talking about, right? We're talking about something in the home that's no longer working like it's supposed to be. Common areas, all right? So they have to be free anything under the control of the landlord. Control of the landlord is also key there. All right. If it's a third party, that's not going to be under their control. They don't have necessarily the authority to do anything there. So common areas must be under control of the land, must be kept reasonably clean, sanitary, free from infestations. They have to allow you to really get to your residence. There's a higher standard for common areas. So if you're thinking, well, I saw trash in the lobby last week, that's not really what we're talking about here. We're talking about something where you're not able to safely walk to your apartment or your residence, right? You're walking through just garbage that, not trash on the floor. You're walking through trash being emptied into the lobby. You're stepping over diapers. You're avoiding feces. Infestation. So if there's an infestation, we'll get to bed bugs in a little bit, but landlords must have appropriate extermination in response to infestation. I specify bed bugs because the law specifies bed bugs, and we will get to that in short order. Have to have the appropriate amount of trash bins and trash receptacles for tenants to be able to throw everything out. And in addition to just having the trash can, it also has to be scheduled for service and emptied at regular intervals. It can't just be like, I got a trash can, the rest is your problem. Nope. Have to provide the actual trash service. Floors, stairways, elevators, railings, they've got to work. Locks and doors on windows. So locks on all exterior doors and locks or security devices on windows designed to be opened must be maintained in good working order. So, for example, years ago, I had an exterior window that just kind of pushed open like that. There was no lock on it. That was a breach of the warranty of habitability. There's no lock. All right. Also, you have to comply with any kind of local building, housing, or health codes, the violation of which would constitute a condition which materially interferes with life, health, or safety. Landlords have to comply with any applicable cleanup standards for an environment or for a natural disaster, an environmental public health event. Okay. Drug lab cleanups. All right. So if prior home was a drug lab, then landlord has to clean it up in the manner and procedures as outlined by the law. Landlords also have to provide a radon advisement. This is something that occurs at the beginning of the tenancy. All right, so tenants have a right to know whether or not the property has been tested for radon, for elevated radon levels. So before signing the lease agreement, the landlord must provide there's a required radon warning statement in the law that must be required of radon concentrations must be disclosed. And finally, they also must disclose the latest copy of the brochure from the Department of Public Health and Environment. The tenant must then sign this acknowledgement saying, yes, I received this information. Cooling device compliance. So landlords have to comply with all cooling device requirements and rules. This is not just, don't think just air conditioner, also think swamp cooler. That's why we're going with cooling device to my knowledge. So what are the rules as we're talking about that? So landlords are not able to prohibit or restrict the use of a portable cooling device. Obviously, I picked a poor picture for portable cooling device. So just imagine it's not installed to the home, but a landlord's able to restrict like a window unit, right? A window unit air conditioner if the installation or use of that portable device would violate building code or state or federal law, if it would violate the manufacturer's written safety guidelines. That could be one. So if you're looking at something, read the instructions to make sure you'd be able to safely install it. If it would damage the premises or render them uninhabitable, or if it would require more amperage than can be accommodated. So those are where a landlord can say no. Other than that, they cannot. But in those limited instances, they can. So if they are in a situation where they say no, then they have requests for portable cooling devices. Landlords are required to prioritize the requests that are coming from disabled tenants for an air conditioner over requests coming from non-disabled tenants for an air conditioner. The law is kind of treating that like a reasonable accommodation almost. And if a landlord does say, no window units, no swamp coolers that you can roll around, then they have to disclose those restrictions in writing to the tenant or any prospective tenant, which means as you're looking for a place, that needs to be disclosed to you at that point in time. They also need to provide information about whether or not they're going to run a operate a common space that will be cooled by a portable cooling device during extreme heat events. And if they are not going to operate a cooled common space, then the landlord will provide information to the tenant or applicant on any known community cooling spaces near the premises, unless there are none known within 10 miles. I think some places, libraries might be cooled community spaces, but I am not sure. I was hoping Deb would say yes or no, but I got a maybe. And that's okay. All right. So if you're looking for cooled common spaces, maybe reach out to Barb as well to say, hey, where can I get some information on this? All right. I'm just throwing y'all under the bus because I don't know. All right. Okay. So if you're entering into a lease agreement, this must now be in it. All right. This bold statement must now be in every lease agreement. And on a portal, there must be a statement in English and Spanish stating where a tenant can mail or personally deliver a notice of uninhabitable conditions. All right. And here we go again. Portal must have that statement in both English and Spanish. All right. So we've gone through some conditions at this point. We're talking about notices, or we talked about it a little bit, but what's a notice? All right. It can be a lot of things. So first of all, it's any writing. Very key there. Any writing that provides a basis for the landlord to substantially know that the condition exists or may exist. This doesn't have to come from you as the tenant. That's obviously the easiest way to prove it. But here are other things. Here are other ways that it could come up. Notice from a governmental entity regarding the condition. The Department of Public Health and Environment, code enforcement. Those are governmental conditions. Let's say the fire department gets called out for a small fire and makes some kind of report of that condition. Well, again, that's an entity coming out to say that. Written notice from third party regarding the condition. So you're caretaking for a friend or a family member, and you notice that there's no hot water and your family member or your friend is just struggling, you can provide that notice to your landlord, or to their landlord, but make sure that you're specifying, who it is and what unit we're talking about here. Could be a notice from another tenant about an issue that affects multiple tenants. Hey, wanted to let you know that the water main broke and we've got 3 inches of water just on the first floor of the building today, right? If the landlord gets that and we've got 4 units on the first floor, gets it from one tenant, well, he's got it for the 4 tenants because the first floor is flooded. This last one is kind of a catch-all. Written observations or reports that the landlord has obtained either directly or indirectly. My best guess there would be that if there is it can be a lot of things, because remember, first words up there are any writing that substantially places them on notice. Okay. So maintenance request, if there is a third-party contractor that comes out to do an inspection and then provides a report to the landlord of here's what we saw, those are observations or reports that they have. But the tricky thing there is, as a tenant, you don't really know that, right? Like, you don't know that the report was given unless you get a copy of it yourself. So best practice, I would say, would be provide the notice yourself, and then move forward from there. So are these the only forms? No, right? That's a non-exhaustive list. There can be other forms come out. So any notice is sufficient if the notice is required or permitted by the rental agreement or by the property rules or regulations. The big thing here is it has to be in writing. If it is not in writing, it does not count, unless your lease agreement allows to give verbal notice. I have reviewed hundreds, thousands of lease agreements. I will let y'all know when I find one that says you can give me verbal notice of the warranty of habitability. I'm sure there's a first time for everything, but it has not happened to me yet. All right, so we've sent out the notice. The landlords received the notice. What are the next steps? Do they have to respond? Yes, they do have to respond to you as the tenant. They have to respond within 24 hours, up to 72 hours if we're dealing with a natural disaster, right? If we think about fires or floods, where I think about Boulder a few years back, where folks just couldn't reach their properties for days. So the landlord has to communicate with the tenant. They have to indicate what their intention is to fix the problem. They have to provide an estimate of when the work's going to begin and when it's going to be completed. They also have to let the tenant know of the landlord's responsibilities under the warranty of habitability to include the obligation to provide a hotel room or alternate accommodation at the tenant's request if we're talking about a condition which materially interferes with life, health, or safety. We haven't gotten to those conditions yet. I promise they're coming. The landlord must also provide at least 24 hours written notice in advance of entry to the residence if entry is necessary to begin or continue repairs. All right. So when you provide that notice, your landlord does have to provide you 24 hours notice, unless we're talking about something super important where we have to get in right now or it's going to get worse. All right. And that's what that little caveat is down there at the bottom. All right. So this is the response. So the response has to happen immediately. When does the work actually have to begin? So if we're talking about materially interfere with life, health, or safety, it's got to start within 24 hours. And the reason for that is, well, think about what we're talking about. We're talking about a condition which materially interferes with your life, health, or safety. That's a problem. And it's going to show these are exaggerated conditions, right? These are larger problems than some of the ones we reviewed in the original conditions. If it's less than material interference, what we just went through, the work must begin within 72 hours of receiving the notice. Right? I promised a specific process for mold. Here's our green little friend. So unless there's something beyond a landlord's control, they must install a containment in the residence to stop water contributing to the mold, and also install a high efficiency particulate air filtration device. That must be done within 3 days of receiving notice of mold or some kind of condition causing dampness, which could materially interfere with, which could cause mold or materially interfere with life, health, or safety. If you're thinking, well, what's dampness that may do that? Think about if we've got a soft spot in the floor and you're worried about going through it. That could be one of those conditions. So we've provided that notice. The landlord's installed the containment. The landlord's installed the air filtration. What are the next steps as we're dealing with mold? That is that they are. All right. And that's to continue running that containment the entire time, establish protections for workers and occupants, eliminate or limit any moisture sources, dry them all out, decontaminate and remove materials that are damaged by mold at this point. Figure out if the resident still has mold. Got to do some post remediation testing. Okay. And then the last step is to reassemble the premises to control sources of moisture and to prevent or limit the recurrence of mold or dampness. Got snug as a bed bug here. So let's talk about these specific requirements. All right. These are kind of a little bit different. And my best guess here is that's because of the nature of bed bugs, right? They can lay dormant for 6 to 9 months. The only way to really kill them is extreme heat, and they can spread. So within 96 hours of receiving a notice that, yes, I have bed bugs, or I think I have bed bugs, a landlord has to provide reasonable written or electronic notice, note on the door, text message of their intent to enter bed or to inspect for bed bugs at least 48 hours before the inspection. A tenant may agree to a shorter timeline. If the landlord, let's say you send a notice over to your landlord, you send a text and they say, oh God, I can have somebody out 6 hours if you want. You can say, yes, I'm okay with that. But if you do not, then it's a 48-hour notice. The landlord must also obtain an inspection by a qualified inspector. I want to sit on that for a minute. Qualified inspector. That's somebody who does this for a living, somebody who has some kind of experience with this. And also the landlord may enter the residence or any contiguous residence for the purpose of inspection. We're talking about bed bugs, they can spread. So that's why we're talking about contiguous residents as well. So the inspection must be done very quickly here. What are the requirements for it? Well, it's got to be done by a qualified inspector. They may inspect the bedding, upholstered furniture, or other items when deemed necessary and reasonable. If bed bugs are found, then they may have access to personal belongings like clothing to see if there's any bed bugs there. If clothing or other personal items are found to have bed bugs, they got to stay in the residence until they're treated, because you take them out, they spread. And tenants have to comply with all reasonable measures for inspection. And if you don't do that, then your landlord can take you to court for an injunction, and you could be responsible for the cost of the treatment. the cost of the inspection, and also the cost of any other inspection and treatment for other units because you refuse to allow yours to be inspected. All right, inspection's done. Now what? So after the inspection, the inspector has to provide written notice within the landlord has to provide written notice within 2 business days of the inspection. The inspector must provide the report to the landlord within 24 hours. If the inspection did not find bed bugs, then this notice from the landlord must also inform the tenant they can contact their local health department if the concerns persist. If it did find bed bugs, then the landlord must inspect any contiguous residences to see if the infestation has spread and begin treating bed bugs as recommended by the inspectors within 5 days. I guarantee you the inspectors do not say, give your tenant $20, tell them to go to Ace Hardware and get a can of Raid. I have talked to folks who have been in that position. That is not how this process works. That is absolutely a breach of the warranty of habitability. The treatment process also includes hiring pest control agents for the residents and any other infested residences. Landlords are responsible for all costs associated with the inspection and treatment for bed bugs. As tenants, we're responsible for the cost of preparing our residents for that said inspection. I've lived through this. It wasn't fun. When the inspection happened, part of the inspection is you got to bag up all your clothes. All right. You got to get all of your food dishes and put them in some kind of pesticide safe tub. So you're probably going to have to go out and buy tubs. That's not something your landlord's going to be responsible for. That cost is on you because you need to get your place ready for that inspection. And landlords shall not rent a unit suspected to contain bed bugs. Going back before, that would just immediately place the unit in a breach of the warranty of habitability. All right. So if you refuse to comply, well, first of all, don't. That's a bad idea. But let's say you have a neighbor that refuses to comply. Then landlords may seek injunctive relief, a court order which requires action against a tenant who refuses to provide access for inspection or treatment. And that order can grant access to the residents, grant the right to inspect and treat, and require the tenant comply with specific measures. And this order must be served on the tenant 24 hours before entry. All right. So, as we've touched on, landlords must provide that notice of entry for the repair work. So they need to tell the tenant the date and time and a reasonable estimate of the time needed for the work to be done in the 24-hour notice of entry. A tenant may accept less than 24 hours notice from the landlord for the repairs to be done, but a tenant may also reasonably deny entry to the residence at the requested date and time. All right. I'm deathly ill today. I have been throwing up for 8 hours and I cannot move. I cannot vacate the home today to get there. I've got a sick kid, something along those lines. All right. There may be other reasons as well. I am just spitballing. If that happens, the landlord then proposes another alternative date and time and the tenant can accept it, or the tenant has to propose a date and time for the landlord to accept. If you tell your landlord, no, you can't come at that time, you are also pausing any kind of timelines for your landlord. It's not your landlord's fault at that point that they're not getting the work done within that 72 or 96 hour or 5-day window because you've said, hey, this doesn't work for me right now. And you've done so reasonably, right? And that's what kind of just covering there. Any timelines are put on pause until another date and time proposed by the landlord is agreed upon by the tenant. All right. Talked a lot about this already, hinted around it, so now we're finally getting to it. These are the conditions which materially interfere with the life, health, or safety of a tenant. If these conditions exist, the law makes what's called a rebuttable presumption, which means it makes that at a baseline, it starts off with saying, this exists, then your residence materially interferes with your life, health, or safety. This is not an exclusive list. A jury or a court could find that some other combination of conditions or a condition that we're not going to cover here rises to the level of material interference with life, health, or safety. A landlord can rebut this presumption, saying the life, health, material interference by demonstrating clear and convincing evidence that the condition does not materially interfere with life, health, or safety. An easy one there that we'll cover here is one of the conditions is to have Adequate heat between October and April. Well, I don't know about you folks, but I haven't really needed my heat the last few weeks here. Maybe it's just me, but that would be a situation that we can all kind of look at right now and say, yeah, if my heat went out in March, the landlord can show it was 75 degrees every day that week, and the low was 55. So that, like we had talked about lack of weatherproofing and lack of weather protection, but this is that extreme issue. That now we have missing windows, missing doors, missing roofs, and weather can just get right in. All right, so if you have an unintentional window, that's a problem, and that probably is going to materially interfere with your life, health, or safety. Hazardous conditions of gas piping facilities, appliances, or other equipment. Because see, we've gone from just maintained in good installed in conforming fashion with the applicable law and maintained in good working order. We're now at hazardous conditions. So we've gone past good working order, and we're worried that our place might blow up. Inadequate running water or inadequate running hot water. So that's going to be where the exceptions where it's beyond the landlord's control, or it's a temporary disruption that they could not prevent or reasonably control. Lack of functioning heating facilities from October through April of each year. So yeah, you need heat in the winter, but you don't really need it in the summer. Any hazardous condition of electrical wiring, facilities, appliances, or equipment. Again, as we're focusing here, well, we talked about that. It's that hazardous part. We're beyond good working order and just, hey, my light switch isn't broke. My light's broken and it's not turning on, or my breaker keeps shorting, and I've got exposed wiring in my bathroom. I've got exposed. I can't plug anything in because I get a shock. I'm tired of it. Lack of electricity or disruptions that are caused by the landlord's failure to maintain electrical wiring, appliances, and equipment. Then we also have infestation of rodents, vermin, pests, or insects. Okay. If you see a couple roaches in your place, that's probably a regular warranty of habitability. But if you can't open your cabinet without your new roommates scurrying off in different directions, that's going to be at this level. Inaccessible fire exits or egress in accordance with applicable building, housing, health, fire, and health codes. Sorry, I said health twice there. Misaligned chimneys or venting systems, any fuel-fired heating, ventilation, cooling system. That's going to lead to death. We're talking about possible carbon monoxide poisoning when venting systems aren't properly doing what they're supposed to do. If you are disabled and you have a disability that prevents you from using the stairs, and the elevator in your building is not operable, and you don't have another way down, that's the problem. You are trapped now. You cannot get out if there's a fire. All right. So we've got a breach of the warranty of habitability. My home's uninhabitable. Doesn't my landlord have to give me some place to stay that is habitable? Not automatically. All right. So a tenant has a right to a comparable dwelling unit that the landlord has and has available, or a hotel room of the landlord's choosing. If the condition materially interferes with the tenant's life, health, or safety, and the tenant makes that specific request for it. All right. The landlord must provide this alternative accommodation within 24 hours of the request itself. So what does comparable dwelling unit mean? It has to have the very little guidance here, but at a baseline, same number of beds that the residence has, right? If you're a family of 5 and they put you into a king bed hotel room, how is that comparable? It is not. All right. You had 4 beds at home. You get 4 beds in the alternative accommodation. That means renting 2 hotel rooms. That's what that means. This is a business. Businesses aren't all profitable at all times. If we have an accommodation that is lasting longer than 48 hours, then the accommodation must also include a refrigerator with freezer and a range stove or oven. Does anybody want to take a guess if a hot plate is a range stove or oven? Show of hands. Who thinks that counts? Nope, not. We're talking about a hot plate doesn't have the same capabilities as an oven. No. And so the range stove has like convection abilities or cooking abilities. So that has you need to be able to bake something. It's kind of not big cookies, but you need to be able to put something in the oven or have a range stove that has that. And a hot plate just doesn't rise to that level. Or let's say can't find anything, or just whatever it may be, can provide tenants with a per diem for daily meals and incidentals for each tenant. That amount is not just whatever your landlord feels like. That is set by the Colorado employee guidelines. I forget which exact one it is right now, but it is in the law. The hotel or accommodation must be located within 5 miles of the residence unless the tenant agrees to a further location. It may be 5 to 10 miles away if it's substantially cheaper, or if nothing is available. I've worked on cases down in Fremont County where it's like, we don't have anything within 10 miles. What do you want us to do? Well, then it's what's the closest available. All right. And if we're talking about a hotel room, there is a maximum date on that, which is up to 60 days of consecutive stay. And that's a situation where the landlord has determined that the condition cannot be repaired within 60 days, provides written notice, which specifies the condition cannot be repaired within 60 days from the start of the hotel stay, that time frame is not based upon the landlord's failure to act or anything like that. The date the hotel room is no longer going to be provided, and that the tenant may terminate the tenancy without penalty. The landlord also has to return the full security deposit on or before the date provided in the notice. And at that point, there's no more hotel room stay. During this relocation period, landlords are required to pay for the cost of the accommodation, a per diem if that's going to be required, like we talked about, when it's going to be longer than 48 hours and there's not going to be a kitchen to be able to do cooking in. And reasonable costs that are incurred due to the relocation. If you had a fire, I'm going back to that one because that's an easy example for me to use right now, and all of a sudden you don't have a roof. Well, you might want to put some things in storage while folks are coming in and fixing the property. That storage cost is something that the uninhabitability brings up. Let's say there's no alternative accommodation within 5 miles, and you're out 15 miles away, and now you've got to take a bus every day because you had picked a place that you could walk to work. Well, those transportation costs are now going to be on your landlord as well. As a tenant, you're still responsible for the rent owed during this time. All right, so here are situations where we're going to have we're going to have an uninhabitable condition, okay? But we're not going to have a breach of the warranty of habitability. And that's going to be if you'd say, nope, you're not coming in for the repairs, it's unreasonable in the denial, and or you engage in conduct which unreasonably delays or prevents repairs to be done. That's going to be very fact specific, so use your imagination. If the uninhabitable condition is substantially caused by the tenant, a guest, invitee, or other person under the tenant's control, then the condition is not a basis for uninhabitability, unless we're talking about a survivor of gender-based violence. All right, so an abuser puts a hole through the survivor's window. We have a breach of the warranty of habitability, right? But the landlord says, no, you had your boyfriend over, you had your partner over, and they put the hole through the window. Your person caused this. I'm not fixing that. That's on you. No, that's not how that works. The hole was put that uninhabitable condition was the result of gender-based violence. That remains uninhabitable. That would be re-victimizing the person who's already lived through something traumatic there. All right. Now we're getting to the real fun stuff. And that's going to be, what do we do if there is a breach? We've given the notice, right? We talked all about the notice. We've talked all about the conditions, all about what we can do. But what can we do if we don't actually get the repairs done? You can terminate the tenancy, move out. You can deduct the cost of completed repairs, or you can replace appliances, you can deduct the cost of completed repairs or replaced appliances from rent. You can sue your landlord. You can get a injunction requiring repairs. You can get a restraining order requiring compliance with the warranty of habitability. You can defend against an eviction action for non-payment of rent, for lease violations, or against a collections action. So those are going to be the big categories that we're about to go through. And I'm trying to be mindful of time here so we can have a little bit for questions at the end. All right, so terminating the tenancy. We've got the uninhabitable condition. We give our landlord notice. We can terminate our tenancy and say we're moving out if we provide then a second notice, which says the uninhabitable condition remains unrepaired. I'm going to terminate my lease and move out. And here's the specific date that I'm going to move out. All right. That date has to be 10 to 60 days from the date the notice is delivered from the landlord. All right. This is the second notice that we're providing because remember, we're talking about a breach. So there's already been a first notice in some way, shape, or form. All right. And there hasn't been that notice. There hasn't been any work done. There's no financial penalty to terminate the lease in this fashion. If you give this notice to your landlord and you say, you know what, it's been 10 days. You haven't fixed anything. I'm terminating my lease and I'm moving out in 20 days. So here you go. If in the next 20 days, your landlord fixes the problem and the house is now habitable, the apartment's now habitable, you can agree in writing to take back the notice to terminate your tenancy and continue on. But that has to be in writing and that has to be signed. A big general point is everything is in writing. If it's not in writing, how are you going to prove it? All right, so that's on just you have an uninhabitable condition. It's not getting fixed in a timely fashion, so we have a breach. You can terminate your tenancy. And that you can terminate your tenancy if we have an uninhabitable condition, it gets fixed, but within the next 6 months, that condition comes back. You may provide at least 10 days written notice within 30 days of the uninhabitable condition coming back to the landlord. And that notice is going to indicate that the condition has recurred. The tenant intends to terminate the tenancy and move out and the date when that's going to happen. And again, if that problem is then fixed, then there may be an agreement reached to rescind that notice and just keep the lease moving. Okay. All right. Deducting repair costs from rent. This is a specific process. So if you have given your landlord notice and there is not any movement being done, you can give your landlord 10 days written notice that you are going to hire a qualified licensed or a licensed of those repairs from your rent. The professional can't be your relative and it can't be you. All right. After providing the notice and then the landlord still does not fix the issue in the required time frame or provide a hotel room at this point, and the tenant receives an estimate from the professional that is consistent with industry standards, then the tenant can hire the professional to do the work at that point. You got to get a receipt for payment or some kind of proof of payment here and provide that receipt to your landlord within a reasonable time or within 30 days of request of the receipt from your landlord. All right, so that's deducting repair costs. But what about appliances? Okay, so you've got an appliance that breaks or it's malfunctioning. You can replace it and deduct the rent if you provide 3 days. Folks online, please keep yourself muted. Provide 3 days written notice of your intention to replace the appliance and deduct the costs from the rent. And the landlord does not repair or replace the appliance with, again, folks, please keep yourself muted online. The landlord does not repair or replace the appliance within that time frame. At that point, then the tenant may purchase a replacement of comparable quality and has substantially the same features and must provide the landlord with the receipt within a reasonable time frame or within 30 days upon request. One thing to keep in mind with if you choose to replace an appliance, remember that's not coming with you when you move. You've replaced your landlord's appliance. All right. And also you're deducting the cost from your rent. So you're not giving the appliance away for free. It's something that you've taken out of what you were going to pay your landlord. So you buy a new refrigerator, the one you really love. Well, I hope your landlord really loves it too, because it's staying there. All right. Let's say we have a big repair cost or a big replacement cost that's going to actually span into 2 months. We don't have to provide multiple notices of that intent to deduct the cost. Just the first notice that we provided before we went through with it. All right. And also, this is where that receipt may be very helpful to eventually provide that receipt as quickly as possible. If a tenant wrongfully deducts rent, then the landlord may pursue any legal remedy available, collections action, or an eviction action. If the court finds that the tenant deducted the rent in bad faith, so it was clear that they were just trying to, get rich quick off something they didn't actually do, the court shall award the landlord double the amount wrongfully withheld. All right. Another option is lawsuit. Very simple. We don't have, and I talk to folks sometimes, I've talked to so many folks over the years where they've been sitting on a warranty of habitability issue and sitting, and there's non-payment accruing. And the whole time, I was just waiting for the eviction to get filed, not knowing that they didn't have to wait. That you can go to court and you can bring this issue up. You don't have to wait for an eviction to be filed. It's a counterclaim, but you don't have to wait. So tenants may file a lawsuit for the breach of the warranty of habitability. So the lawsuit would be requesting actual damages. This is different than an injunction or a restraining order, which we'll get to in a little bit. This is just about the money. All right. So that means that what are damages here? Any kind of replacement cost for some items, but a reduction in the rental of the rental value of the uninhabitable property. Also can recover court costs. If you hire an attorney to represent you, they can recover attorney fees. You can also receive punitive damages. Those are damages just to punish a landlord. All right. Meaning this is not, I didn't actually spend this much out of pocket, but your actions were so bad that we're going to punish you for them. And any other damages is ordered by the court. If you're sued by a landlord or a former landlord, you can also raise the warranty of habitability as a counterclaim, which means you can also raise that as a counterclaim in an eviction case as well, in addition to it being a defense in an eviction case. We're going to get to the defense part in a bit, I promise. All right, you can also obtain injunctive relief, either preliminary or permanent in a district or county court. And if a court orders specific performance, then the specific performance means the court's going to tell the landlord, hey, you need to do A, B, and C. And that's going to be that it can contain orders to remedy existing violations, including to any similarly situated tenants, cease or modify practices that give rise to uninhabitability, or adopt practices or policies to ensure habitability or minimize uninhabitability in the future. Court can also determine actual damages to be awarded to a tenant for an injunction. Injunctions also typically will accompany a lawsuit themselves, but an immediate temporary restraining order would not. If you've heard of a restraining order, you've probably heard of it in the sense of violence. Somebody has assaulted somebody else, somebody has threatened somebody else, and if we don't stop them from contacting the person, this person's going to be at risk of being assaulted again, being threatened again. But that's not what we're talking about here. We're not talking about assaults, but we are talking about restraining orders where the residence materially interferes with the tenant's life, health, or safety. So we have that threat to safety. The landlord has not fixed anything. They're in breach. So how do we force this to happen? They're not giving me a hotel room. They're not sending anybody over here. What am I supposed to do? I don't have a door. Then the tenant can go to court without notice to their landlord and file a request for a restraining order because your life, health, and safety is at risk here. The restraining order, so you have to show that the landlord knows about the condition and has not complied with fixing the problem. And as a tenant, you certify to the court all the efforts you've made to try to obtain landlord compliance. Multiple notices, whether you've offered to hire people and it's just been unreturned, or if you've provided, reports of what to do and there's just nothing happening. So this request may be granted by the court upon a finding of these facts, and the order may be granted, dissolved, or modified in accordance with civil procedure. Tenants don't have to post a bond for this, and they don't have to show irreparable injury, loss, or damage to get a restraining order. That's something that you're going to see more on an injunction level. But this can also require landlords to comply with the warranty of habitability. If we're talking about compliance, that could include providing that alternative accommodation. Because remember, we're talking about a condition which materially interferes with life, health, or safety. That's a requirement for a restraining order. So if we're talking about life, health, or safety, then we're also talking about a possible right to a hotel room. So one part of the relief that can be sought in a restraining order is for a hotel room and for your landlord to do the repairs themselves. Right? So that is another option when we're dealing with a breach. A lot of times what we'll see happen is we will see rent being withheld because there's an uninhabitable condition to try to get the landlord to actually, do the repairs. The landlord turns around and says, nope, you haven't paid your rent. I'm going to evict you. It is a defense against a breach of the warranty of habitability is a defense against an eviction for the non-payment of rent. This must be raised in an answer or other pretrial filing. If you just walk into court on a day of a hearing and go, actually, Judge, it's the warranty of habitability, they're not going to let you use it because you never included it in an answer. Don't have to post a bond, don't have to accrue any expense, and you also don't have to have tried to use any other remedy under the law here. You don't have to have tried to deduct costs of repairs. You don't have to have sought an injunction or a restraining order. You can just defend yourself against an eviction. So if the tenant raises this defense in their answer, the court is going to issue an order for the exchange of evidence. The court is going to order that the parties exchange all of the relevant documentation, notices, responses, correspondence, maintenance reports, at least 96 hours before a hearing in the case. If the landlord's not providing that documentation, that may result in the case being continued or the evidence itself being excluded. So what records does your landlord need to keep here? We just went through, well, I got to turn all this stuff over to you. What stuff do they have to keep in the first place? Well, landlords have to maintain accurate and complete records of all notices, all correspondence, and all documentation relevant to any condition or action taken to repair the condition. And they must maintain these records for the entire tenancy and the 3 years after the tenancy ends. The 3 years after the tenancy ending would be the statute of limitations for a claim. And landlord shall provide to the tenant any record upon request. All right, so the warranty of habitability as a defense to eviction for non-payment, like we talked about. This must be, again, please mute yourself online, folks. If it's included as a defense in the answer, then you must prove by a preponderance of the evidence, 51%, more likely than not, that there was a breach of the warranty of habitability within 60 days before or at any time during the alleged non-payment, or at any time during the tenancy and the condition continued into the period of alleged non-payment. Let's say this has been something that's been going on for a year and nothing gets fixed. The condition does not need to exist at the trial to use it as a defense. All right. It is also a defense for a non-monetary reason, right? If there's a breach of the warranty of habitability and then your landlord turns around and says, you've violated your lease and I'm evicting you for it, the tenant must show that the alleged breach of the lease arose primarily from a breach of the warranty of habitability. What does that mean? It's going to be fact dependent, but it means if you're saying I breached the lease, the only reason that is because you breached the warranty of habitability. And also it's not a defense if the landlord then proves the tenant committed a substantial violation. All right, so you've gotten through the hearing at this point. You've presented your evidence. the court is making its ruling. What kind of ruling might you expect from a court in this situation? Because remember, we're in an eviction case, okay? If the tenant proves there was a breach of the warranty of habitability, the court shall deny possession to the landlord and deem the tenant the prevailing party so long as the tenant pays any rent owed within 30 days. That means the landlord loses the case, you win the case, and you have 30 days to pay the rent. Well, hold on a second. I was just withholding my rent because my home is uninhabitable. All right, we're going to get there. Don't worry about that because the court's also going to order the rent be reduced. So the court's going to order the landlord to repair any existing uninhabitable conditions within a specific time frame. That's going to be including to continue any repairs they're doing, compliance with any other obligations under the warranty of habitability, and may also order specific performance or injunctive relief. The court's also going to order a reduction in the fair rental value of the property. So you're not going through all of this to then have the court say, you're right, there was a breach of the warranty of habitability. Now go pay all of the rent, right? That seems inherently unfair because you didn't get what you signed up for in the contract. You agreed to a property that's habitable and you were living in a property that's not. There needs to be, money is what makes up this difference. So the court's going to order that there's a reduction in the fair value of the residence. The court's going to order the landlord to reimburse you for any difference between the reduced rent value and what you've paid. So if you've paid more than what it was worth, you're getting reimbursed. The court's also going to award court costs and attorney fees and determine whether there's any rent owed period after they take into account expenses, damages, court costs, attorney fees, and any other counterclaims that the tenant may have against the landlord. All right, well, what's the reduced rent market value? We just throwing darts at a dartboard here? Nope. So there are two presumptive levels here. The law is going to presume that if the home is uninhabitable because it's in a condition which materially interferes with your life, health, or safety, that's worth $0. It is worth $0 to put your health, life, and safety at risk. If it is a condition that is less than that, 50%. Now, these are rebuttable presumptions. So again, these can be overcome by the landlord by a showing of clear and convincing evidence. What happens if if you put on your evidence and at the end of the case, the court says, I don't agree. If the tenant does not prove the breach of the warranty of habitability, but still brings the claim in good faith, and the landlord proves their non-payment claim, the court shall provide the tenant with 14 days to pay that full amount. All right. If the tenant pays the amount due within that time frame, then the case shall be dismissed. Going back here, whoops, that's not what I want. The court's going to give you 30 days to pay that reduced rent amount. If you don't pay that amount within 30 days, you will then unwin the case. You will lose the case. So, because if we think about it, we withheld our rent because we had other costs that arose because of the warranty of habitability, or because, hey, this is not worth that much. When the court makes the determination of the reduced rent value, at that point, that's kind of that fairness of, all right, now we have a reduced amount. This represents what the rent should have been, and I am going to pay that now. And if you don't do that, then you're getting evicted. Same if you don't, stop doing that. If you don't pay within that 14-day period. If the tenant brings the defense and the court finds that the tenant brought the defense frivolously or for the purpose of unnecessary delay, then there's not going to be any second chance to pay the rent there. All right, there's that 14-day period. If you brought it in good faith and the court says, no, there wasn't a breach here, but I see where you're coming from. All right, it is also a defense against a collections action. You've moved out, process server finds you, and now you've got a court date for unpaid rent. It's a defense that there was a breach of the warranty of habitability, and that would also then work in a collections action as well. You think about it, same kind of procedure of trying to figure out what would prove the breach, and then what's that reduced rental value. All right, we're close to questions. Thank you all so much for bearing with me here. We're actually going to have time for a decent amount of questions tonight if we want. So the last bit here, little ending note. Second to last ending note, I got one more little fun fact after this. So retaliation. Right. Let's say you go to this meeting here that Lisa was telling you about, or you make a good faith complaint to your landlord about the warranty of habitability, or to a governmental organization, like you call code enforcement. Your landlord's not allowed to retaliate against you for those actions. What do we mean by retaliate? Retaliate doesn't necessarily mean, well, now they're looking at me funny and they're giving me the side eye. That means that we're increasing rent, we're decreasing services, we're terminating a lease without our permission, unless it's allowed by law. We're threatening to bring an action for eviction, or we're taking any action, our landlord's taking any action that threatens and intimidates, discriminates, or retaliates against the tenant. Retaliation is a defense against eviction. Okay, but this is one of my cliches that I fall back on a lot because it's true. It's not what we know; it's what we can prove. Okay, and what we need to prove in a retaliation claim or defense is we need to prove that the protected activity, that organization, or that complaint about the warranty of habitability to the landlord or a governmental agency was a motivating factor that influenced the landlord's decision to engage in the retaliatory actions. Gonna need something, right? Is timing something? Yeah, but it's not enough. Timing alone is insufficient to prove intent. All right. Other resources here. What are these governmental agencies? You can contact the Colorado Springs Planning Community Development Neighborhood Services Office. You can contact the Department of Health, the El Paso County Planning and Community Development Office. And then my parting thought before questions here is code enforcement. I've mentioned code enforcement a couple times. We are talking about two different statutes here. All right. Code enforcement enforces the city's minimum housing standards of the city code. Okay. The warranty of habitability comes from Colorado statute. The city code is going to vary city by city, municipality by municipality. So code enforcement is going to enforce what's local. They're not there to enforce the warranty of habitability, right? For example, mold's not in code enforcement. It's not. You know what isn't code enforcement? That's not in the warranty of habitability. Screens on windows. Yeah, so it's not a one-to-one. Are you going to have a lot of overlap? Sure, absolutely, but it's not the same thing. And also you can call both. You can provide your landlord with a notice and also contact code enforcement. Here is my contact information. Also, if you were online, folks, if you registered for the event, should be emailing slides out. Yes?
Yes.
All right, perfect. I will just have to email them over to Barb tomorrow or the day after. Please don't be mad at Barb. If I don't do that on time, be mad at me. I'm very, very sorry. I'm just trying to keep myself swimming like everybody else. But all right, so we've got plenty of time for questions. Don't be shy. Yes, ma'am. Yes.
So it's not misconduct. Survivor of injury survivor. Is a statutory economic damage in relation to a warrant to that? Like say there was violence, door broke. Is that a warrant situation or is that something?
I'm a bit confused by your question, so let me see if let me ask it back to you to see if that's what you were asking me.
Okay.
If there is some kind of altercation and a door breaks, is that subject to the warranty of habitability?
Yes.
It depends. Okay. So if the door breaking is the result of domestic violence, domestic abuse, unlawful sexual behavior, or stalking, then it's not, then as the survivor, you, the tenant, are not, that's not going to be your misconduct. So at that point, that would be a breach of the warranty of habitability. Okay. But if you come home and you had a bad day and your key's stuck and you put your boot through the door, no, that's on you. Okay. So, did I
Yeah.
hear your question correctly? There is the economic statutory development that really threw me for a loop there.
Yeah,
Oh, it's not in my slides. I'm like, where am I? I don't remember that phrase. So statutory damages. So the question was for folks online, what are statutory economic damages? It's going to depend case by case, but you're saying by statute, okay? So by statute, I would say the damages would be the reduction in rental value, okay? Because that's the only, because I'm going to harp on the word statute here, which means we can find it in the law, all right? And that's the specific provision of the law, which says, hey, here's what we're looking at for reduction in rental value. Here's what our baseline is going to be, whether that's 0 or 50%. Actual damages beyond that are going to, let's say, as an example, you didn't have heat, your landlord didn't do anything, you went out and you bought a space heater. That could be an actual damage. You wouldn't have had to buy the space heater, but for the breach of the warranty of habitability. You have material interference with your life, health, or safety, and you got to go rent a hotel room for the night because you don't have heat, and it's that weekend, it's that one weekend of the year where the temps don't get above 0, right? Or your pipes burst, and you got to get out of there, and your landlord doesn't respond. Those could be damages. But beyond, so statutory damages, those are going to be in the law and in my mind, I'm only thinking of the rent amounts. Actual damages, those are going to be fact-based. Okay. What did you lose or what did you pay out of pocket because of this contractual breach? Okay. Sure. Mm-hmm.
and I mentioned my other neighbors mentioned like, hey, it's hot. And it stayed on through summer, and finally winter was here and summer.
So I cannot answer your specific question, but I want to talk. That's a really good question that you asked. My heat won't turn off in the summertime, right? So what does that mean? Does that sound like your heat's not turning off in the summertime? Yeah, not yet.
In gas facilities,
Fair.
slide 14-ish. Yeah. Yes, my Excel was up the roof.
Heat. You've got heat that's where I'm thinking.
Yeah. Slide
Okay. Yeah, so let's look at slide 16 here. We're talking about, so the question was, what happens if my heat is running all summer? Well, that doesn't sound like it's being maintained in good working order if you're fighting the thermostat for trying to get below 85 degrees in July. Okay, so that's a situation where it's very odd, but that sounds like to me the heat's not in good working order because it's July. That's a really good question. If that were to occur in the future, I would recommend providing a notice about heat. Yes, do we have online questions? Okay. Yeah. That sounds good. Let's do that. And I'll just start tackling those. We've got about 20 minutes yet. We've got about 20 minutes left, folks. I want to thank you all for being here tonight, by the way. This doesn't work without butts and seats. All right. This year we're doing, this is not the same presentation that will occur in June. And so each presentation this year has an intended subject matter. And tonight was the warranty of habitability. I believe June's going to be lease literacy and going through leases. All right. So I am going to go through the questions that were entered into the chat online. What is the best advice you would give a self-represented tenant when it comes to drafting a demand letter? That is a very broad statement. The best advice that I can give is make sure that you are actually stating what it is that you want. If you are stating compliance with the warranty of habitability, indicate what the uninhabitable condition is. If you are making a request for a reasonable accommodation, state what specifically you want, what accommodation you need specifically, like a grab bar in the shower or a reserved parking space. It's just a little bit too vague and broad for me to answer beyond that. The next question is, how much time does a landlord have to give you to accept a lease renewal with a lease increase? The law does not. So I hope everybody heard that question online, was how much time does a landlord have to give you to accept a lease renewal with a lease increase? I'm going to assume that means rent increase. The law doesn't, there's going to be two things here. The law doesn't specifically talk about, hey, this is how much time you have on a lease renewal. But the law does say if your landlord wants to raise your rent, they must provide you with 60 days written notice. If we put those two together, any lease renewal offer that contains a rent increase must be provided at least 60 days in advance because it's a 60-day rent increase notice requirement. Renters have rights, but also have responsibilities. What right? Yep. We went through we went through those responsibilities earlier. What rights do you have when there is a house fire or an apartment fire? Are you able to retrieve your belongings? There's two questions. What rights do you have when there is a house fire or an apartment fire? Those are likely going to be warranty of habitability issues, and you would have the rights from them. Those are the rights that we covered all evening here. About your ability to retrieve your belongings. I don't know that that's actually covered by really the warranty of habitability or landlord tenant. And that may be more in kind of Department of Public Health Environment, kind of like disaster cleanup. So I don't know is the honest answer. And I would look at kind of CDPHE rules on environmental cleanup or call Firehouse. Ask them. My landlord has said 3 years ago the backyard will be taken care of. That's not a question. I don't know where it's going, and it's also too fact specific for tonight. So if you're online listening to this, what I would recommend is to mark on your calendar that April 14th date at the Family Success Center, and there will be Ask a Lawyer clinics there. Additionally, if you just cannot wait, Wednesday nights 7 to 8:30 is the Justice Center's Call a Lawyer clinic. If you're thinking, hey, I'm going to call on 6:30, that way I'm first in line. No. Call when the clock turns over to 7 o'clock. They have different recordings, different answering services. At 7, it switches over. All right. Can I be charged a monthly fee for pets? Yes. Can landlords charge for damages if there was never a signed walkthrough? Yes. That's why tonight we didn't cover security deposits. But if you're moving in, if there's not a signed walkthrough, don't let that prevent you from documenting the condition of the home, the apartment when you first move in. Before you unload one box from a truck, you go inside with your camera, you take pictures, you take videos, you take pictures, you show lights, you show faucets, you show cabinets, you show everything. Then you save them. And in 6 months, 12 months, 18, whatever it may be, when you're moving out, you go look at those photos and you go around and you take the same photos again. Right now you have bookended evidence of this is what the condition was. All right. But so without that, it's just harder to prove conditions at the beginning of a tenancy. Why is rent so expensive and there are empty buildings? Capitalism. If a renter is a tenant at will, do they have the same rights and protections as a renter with a lease? Yes and no. Tenancy at will only has a right to a 3-day notice to quit. Are landlords required to offer a cost-free method for tenants to pay rent if the landlord does not derive any financial benefit from requiring tenants to utilize cashiered checks for payments? That's a really good question. And I will be candid, there was a new consumer law passed or went into effect in January of this year, and I do not know that answer off the top of my head if that affected charging for rent payment options. When I'm renting, can the person I'm renting from come into the property that I'm renting? In certain situations, yes, but that's going to be a situation by situation or a case by case analysis. One thing to keep in mind is that when landlords rent us the place, what they are selling to us is the right of possession, right? When I say the right of possession, that means we get to possess the property to the exclusion of other people. All right? It's ours to hold on to. We can say no. Right? That's what the that's what the right of possession is. The landlord has a duty to deliver possession, but at the end of the day, it is also the landlord's property or their managed property. And if they, as a tenant, you want your landlord to be fixing the property up and keeping it maintained. So there's competing interests here, but it's not a simple yes. The answer is yes. In some situations, yes. I have an active eviction case and I have questions about the repayment plan that I have. That's going to be too fact specific for this evening's presentation. I would recommend contacting the Justice Center's Call a Lawyer Clinic tomorrow night if you want a quick answer. You can also contact CLS for possible advice on that situation. Does a lady who leases properties for people under her own LLC need a real estate license to do leases? Depends on the jurisdiction, depends on the locality, right? I think Fountain, yes. Colorado Springs, not to my knowledge, but I do believe Fountain has requirements for landlords to be registered. Does the same lease manager have the right to schedule a service guy for 8:30 a.m. on Sunday with 2-day notice on a non-emergency item that was broken prior to me renting the property? We're getting a little too fact specific. So we're just going to have, these are going to be a little bit beyond what I can answer this morning, just because they are too fact specific and require kind of looking at the lease itself. Oh, this is a really great question. Does warranty of habitability apply to trailer parks and mobile homes? If there are differences, what are they? Yes and no is the answer. If it is a owner occupied home, you own the home? No, doesn't apply. It's your house. Right? Landlord's responsible for the lot itself and the pedestal and making sure all the utilities are connected. But if you're renting a home in a mobile home park from the park, yeah, you're renting. You don't own it. It's not your responsibility. It's not your property. All right. Those are the main differences. Also for mobile home tenants, keep in mind, there is the Mobile Home Park Oversight Program, which is a dispute resolution program. If you are having issues in the park, you may file a complaint with the Mobile Home Park Oversight Program. So John, to answer your, yep. That I just saw that you saw that, but that's a great question. If you are running into that situation, I would recommend reaching out for advice, especially if you've got an issue underneath your trailer with a water connection issue. That can get really messy. So if it's a connection and the problem's on the park side, you want to address that as quickly as possible. That's all in the chat there. Folks, we've got about another 10 minutes for any other questions, if anybody has them. I'm seeing no hands inside the room. Do we have any hands online? I'm not seeing anything that anybody's typing up a storm right now. All right, folks. Going once, going twice. Thank you all so much for being here tonight. Thank you for your thoughtful questions and being with us, and hopefully see y'all in June as well. Thank you.
Thank you, Clinton. And thank you so very much. Just one last reminder, as long as we have your email address, we'll send you the recording and the slides. So again, thank you, everyone. Have a great evening.
Thank you.